name is Ben Miller, and I am an attorney with MNK Law. At MNK Law, we represent businesses and help them successfully navigate through various legal challenges that arise at all stages in the life cycle of a business, from formation to the operation of the business to the sale or winding up of the business. In this short video, I will tell you about 5 important parts of a letter of intent. A letter of intent, sometimes referred to as a memorandum of understanding, is a pre-contractual document that sets forth the basic terms of a prospective transaction between the parties to be finalized in a subsequent definitive agreement. Letters of intent are typically intended to be non-binding and are used in a variety of transactions, including asset purchase agreements, equity purchase agreements, and even employment agreements. With that, let's talk about the first important provision that parties to an LOI should consider. Number 1, non-binding. Although most parties assume their LOI is non-binding, it is essential to include a provision that explicitly states the LOI is intended by the parties to be a non-binding statement of the terms and conditions under which the parties will attempt to negotiate a formal and binding definitive agreement. Parties must take special care to ensure that this provision applies to the entire LOI, if that is their intent. Some LOIs may include binding obligations as to certain terms only, and any binding provisions should be explicitly limited to the terms which are intended to be binding. Number 2, exclusivity. This provision may be requested by the buyer, and it prohibits the seller from dealing with any other party with regard to the potential transaction during the stated negotiating window. This allows the buyer to fully invest time and resources in due diligence and negotiations for a definitive agreement without the risk of the seller shopping for a better deal and leaving the original buyer with nothing for its efforts. Number 3, due diligence. Due diligence is an important part of every transaction, and a general framework for how due diligence will be completed should be included in the LOI. In the case of a purchase and sale agreement, the LOI should state that the buyer will be granted reasonable access to the business and to all documentation pertaining to the business, such as financial statements. The LOI should set forth the timeline for due diligence to be completed, and the parties should budget adequate time for reviewing all the voluminous documentation that should be included in due diligence. Number 4, transition assistance. For transactions in which there is a purchase and sale of a business, particularly a closely held business, the buyer may want to have the seller or key employees of the seller remain with the business after the transaction to assist with the transition. The LOI should set forth the basic terms for the employment of such key employees for a specified period of time, to be later finalized in an employment agreement that will be ancillary to the definitive purchase and sale agreement. The LOI should also include details about other items to be transitioned under the new ownership, such as lease agreements, supplier contracts, and customer contracts. Number 5, non-compete. The buyer should also request a non-compete provision in the LOI if desired. This will prevent the seller from opening a new business to compete with the business acquired by the buyer. The non-compete provision in the LOI should specify appropriate temporal and geographic parameters. These are just 5 important provisions that a well-written LOI may address. There are other important aspects of an LOI that are beyond the scope of this video. If you are considering buying or selling a business, we recommend you seek the counsel of an experienced attorney to guide you through this process, including the LOI. If you have any questions, please visit us at mnklawyers.com or email us at info@mnklawyers.com. Thank you.